Alternative trade remedies in the customs perspective, focusing on the Enforce and Protect Act of 2015. My name is Justin Miller. I'm a senior trial counsel with the Department of Justice. And as with Judge Gordon, I give the general disclaimer that these remarks today are my own and do not represent the views of the department. And with me today, to my immediate right, is Emily Simon. She's an attorney with the Entry Process and Duty Refunds branch of the Office of Regulations and Rulings for U.S. Customs and Border Protection in Washington, D.C. To her right is Nathaniel Rickard, a partner from Picard, Kentz, and Rowe. And to our farthest right is Mr. Richard Wortman, a partner with Grunfeld, Desiderio, Leibowitz, Silverman, and Claystad out of the Los Angeles office. So today we're going to be discussing EPA, a statute that came into effect a little over a year ago. And as we heard earlier from Judge Gordon, there's been an increased focus on targeting enforcement actions generally within the United States, but with respect to the EPA, it's targeting duty evasion. Duty evasion has been of particular concern for the trade community for a number of years, and the statute upon which EPA was based had been debated for a number of years as well, and it wasn't until last year that it was successfully passed and enacted. So today, as we discuss the parameters of EPA, we have a hypothetical factual situation to provide a little bit more context. And our hypothetical will focus on these cups that you see here before you today, sippy cups. And under our hypothetical, there is an anti-dumping duty order in place for extruded and or molded plastic cups. So those would be the ones at the far right of the podium. These items would be were brought by a petitioner for an anti-dumping duty order, and they are within scope order, and they receive up to 200% in anti-dumping duties. You have a separate manufacturer of the sippy cups. They're bringing them into the United States. On their import papers, they describe them as plastic children's cups. A question arose as to whether these items should be subject to the order. The importer revised its entry papers and described the merchandise as sippy cups. Suddenly, then, it triggered an investigation by the U.S. Customs and Border Protection as to whether there has been an invasion of duties, an invasion of the order. And as we discuss further what the parameters of the EPA are, we can use these items as a useful example in discussing exactly what evasion is and what are some of the concerns and issues that both foreign manufacturers and importers and domestic industries consider when they decide that they want to pursue relief under the EPA. So with that, I'm going to turn it to Emily, who will give us an overview of the statute.
So good morning, and thank you for having us here today. Again, same disclaimer, the remarks that I will make today are my own and do not represent those of U.S. Customs and Border Protection, and all remarks should be considered off the record. So with that said, let's talk about not just this scenario with regard to what does or doesn't constitute a sippy cup under the scope of an anti-dumping order, but I want to situate this a little bit more generally for you in terms of how AD/CVD enforcement works. So as many of you know, the Department of Commerce and the International Trade Commission are responsible for the AD/CVD orders and setting the rates that apply. Customs' role in this process is what we refer to as a ministerial role. We do not decide the story behind the story, if you will, as Judge Gordon referred to, as to what is or is not within scope of an anti-dumping order, but we are responsible for its enforcement. That is sometimes a very straightforward endeavor, and sometimes it is not for Customs and Border Protection. So when we talk about EPA, the Enforce and Protect Act, it was introduced to help CBP facilitate the process of AD/CVD enforcement. That is not to say that we did not have AD/CVD enforcement prior to EPA, simply that the mechanisms made available to us did not exist. And the reason for that is because we are a law enforcement agency. Generally in our proceedings, we do not engage with the public when we are pursuing a potential evader of AD/CVD. There are certain confidentiality concerns and other aspects of law enforcement investigations that would preclude that on an ordinary level. However, EPA changed the landscape by allowing other parties to engage with CBP in an effort to enforce AD/CVD orders. So, obviously, from the perspective of domestic industry and the petitioners who pursue the AD/CVD orders, this was an important option to make available to them. Why the frustration? Well, one of the common criticisms of CBP for AD/CVD enforcement is that we move too slow and we often aren't in a position to collect, if you will, the additional duties that are owed by the time we determine that there's been evasion. So we move forward with EPA in a way that should speed up investigations and allow the trade to participate when they have knowledge. E-Allegations is a CBP website that allows the public to bring to CBP's attention on an anonymous basis concerns, if they wish it to be anonymous, you certainly could identify yourself, but concerns about any kind of trade violation, including AD/CVD. Before EPA, that was the way in which the public could provide to CBP tips about evasion. EPA created a more structured process where the black box, which is what e-allegations was referred to by a lot of the AD/CVD petitioners, was no longer a black box, but now an opportunity for a more transparent process. So within 180 days after the Trade Facilitation and Trade Enforcement Act was passed, CBP had to promulgate regulations. And that's a huge endeavor for any administrative agency. What we did was we issued an interim final rule so that the rule became effective immediately and the agency collected comments. And in the future, we will issue a final rule based on our experiences up to that point with respect to EPA enforcement. So the interim final rule came out, and it took what Congress provided to us under EPA and created a much more significant framework with timeframes, notice requirements, and all of the other sort of regulations that you would need in order to have this kind of process. So this process, while it might seem kind of like some of the other processes you see in the Department of Commerce and the International Trade Commission, it is not exactly that. It does involve public engagement, but we don't operate under administrative protective orders and those sorts of mechanisms that make it a much more involved process when the orders are actually being issued and the rates are being set. So what EPA did was it gave us essentially a 1-year time period, and I'm sort of rounding, for investigations to take place. It requires the agency to provide technical assistance to small businesses that might wish to engage. So if, for example, a small business that may be domestically manufactured, some kind of product similar to some of these other things that you see up here became frustrated because they thought that these sippy cups are being imported with a lower rate of duty and should be subject to AD/CVD. If they had concerns about those sippy cups, they could come to CBP in advance where we would provide technical assistance to them. That's one of the things EPA did, again, in the spirit of being facilitative in this process. Now, what happens generally in an EPA investigation is that certain members of the public have the right to file with us an allegation. These interested parties submit to CBP electronically on the e-allegations website by selecting the specific option for EPA, an allegation that establishes certain criteria that we require in order to move forward with an AD/CVD investigation under EPA. And evasion here in this context simply refers to bringing goods into the country that should be subject to AD/CVD at a specific rate and either paying a different rate or no rate at all, so that you could engage in evasion by giving us false case numbers, maybe for lower rates, or no case numbers at all. Oftentimes, there are misclassifications involved when you're looking at evasion type scenario so that CBP may not be as aware of what you're doing. And I want to stop right here and point out that when you are in this sort of situation as an importer, classification is not dispositive with respect to the scope of anti-dumping and countervailing duty orders, but it is often an indicator or a flag for CBP that if a specific HTS provision is called out in an order, of course we're looking for that on importation. So a very common form of evasion is going to be misclassifying goods under a provision that's not called out in an order. So that's worth noting. And if you look at the fact pattern that you have, I also can't help but point out as a customs attorney that deferring to your broker for classification can often be a dangerous endeavor. And so one thing that importers should be careful of is always to engage in reasonable care when classifying their goods. And again, broker deference, especially without providing brokers all the facts regarding what goods are. When it comes to AD/CVD orders, that importer of record is still on the hook for the anti-dumping and countervailing duty liability. And at the end of the day, even though I think a prior disclosure was hinted at in the fact pattern, you are always liable for the AD/CVD that would apply to your goods, even if you didn't know you brought them in. Now, it's worth pointing out that for EPA investigation purposes, if you didn't know because of a clerical error that your goods were subject, or that's why you didn't report them as being subject, you would not be within the scope of an EPA investigation. That's carved out by the EPA statute. However, you would again still be liable for the payment of the AD/CVD duties. So with that in mind, once an EPA allegation is filed, and it must identify not only the party that's making the allegation, but the party against whom the allegation is brought, the AD/CVD orders in issue, and the nature of what is believed to be the act of evasion. And an EPA allegation has to be based on information that is reasonably available to the party that brings it. So we can't, for example, expect a party to have access to trade data that is confidential or proprietary, but we would expect certain information to be contained in those allegations. And I think some of the other panelists are going to touch on what CBP has and has not been allowing in this context. But CBP has a 15-day window from the time of receipt of an allegation to make its determination as to whether or not the agency is going to investigate. And we have attempted to be quite transparent in this process. If you go to the CBP website, we do make available the checklist we use to ensure that an EPA allegation at the time of receipt is complete, as well as the checklist that we use to determine whether or not it reasonably suggests that there is in fact evasion going on. And CBP has also made efforts, and I will leave that to the other panelists to discuss, to be transparent with respect to those cases where it has decided to move forward with the investigations. So that is really the genesis of where the EPA process starts. And we have the initiation, of course, followed by investigation, and then appeals. And the way that this panel is structured is we'll touch upon the next two phases, both the investigation and appeals, during the course of our discussion. So we'll talk about that in a little bit more detail as we move on. I know Justin has some questions for this particular phase, but I want to point out that the investigation that is begun at this process, and there's a 300-day time frame for the investigation to be conducted, or 60 additional days, up to 360 for an extraordinarily complex type of case. We have to make our determination within that window, which arguably is a lot shorter than the sort of substantial investigations that are conducted without notice to the public regarding AD/CVD violations. So that really kicks off the process. The investigations are conducted. They're led by CBP's Office of Trade within the Trade Remedy Law Enforcement Directorate, which is one of 5 directorates in the Office of Trade. But they work not only within that directorate, which oversees the investigation, but with the assistance of auditors and the folks in the field. So in the hypothetical scenario that we have, if you have a request for information that comes in asking about AD/CVD type situations, that may, but does not necessarily mean that you could be subject to an EPA investigation. So I want to point that out. It's a red flag, certainly for any importer, anytime CBP possibly suggests that you could be subject to AD/CVD.
Thanks, Emily. I think it would be provide good context if I read what the actual statutory definition of evasion is in this context. And the statute defines evasion as entering merchandise by means of any document or electronically transmitted data or information, written or oral statement, or act that is material and false, or any omission that is material and that results in any cash deposit or other security or any amount of applicable anti-dumping or countervailing duties being reduced or not being applied with respect to the merchandise. That's an interesting definition. Emily, would you like to speak to what that means?
Well, it's not just what it means, but what I think it doesn't mean in this context that's important. You don't have to intend to actually evade. There doesn't have to be the same level of culpability that you would expect in a 1592 investigation for negligence, gross negligence, or fraud. This is simply the act of evasion and what you may have done to contribute in that regard. And I think you're going to see importers, and that's certainly the target of EPA, being pursued on that front.
Thanks. Nathan, who are bringing allegations? Who are the entities that we are seeing are filing allegations under the EPA?
So under the current, with a year of experience, what CBP has seen so far is EPA allegations filed by domestic industries, domestic producers. But what makes EPA interesting in the trade field, I think, and it goes to kind of what Richard's going to be talking about, is there isn't a lot of opportunities for foreign exporters and U.S. importers to get involved informally in proceedings about enforcement of trade remedies. And quite often, the U.S. importers and foreign exporters may have as much of an interest in enforcement on the trade remedies as do the domestic producers. And so EPA, as a statute, permits both importers and foreign producers to also file EPA allegations, which is not something that they can really participate in at the commerce level of trying to get increased enforcement, but they will have that opportunity within EPA, and we'll see whether or not that is something else that there are more allegations coming from those parts of the trade community.
Thanks. Richard, speak to us a little bit about notice. When will the party who is subject of an invasion allegation receive notice?
Well, at least in theory, under the EPA timetable, there's going to be at least a 60-day period which there's going to be radio silence. Having said that, this week, an EPA case was made public to a company called American Pacific Rubber. And I just want to pull out the relevant dates from this case as it's stated in the public version. So the domestic manufacturer filed a complaint on June 21st. On July 18th, Customs initiated a review. And on October 23rd, the case was made public. From a practitioner's point of view, I should say that one of the biggest problems that we see in this case using EPA is that a broker and or an importer may not know that they or their client is under investigation. And what happens during that period is that Customs is often out looking for information. And one of the ways they do that is they issue what are known as Customs Forms 28 and 29, requests for information. And using those forms, they're asking for lots of information. I will tell you from the practice, the day-to-day practice of customs law, most of those are responded to in a slipshod manner, especially by brokers and importers who just kind of say, here's a pile of papers, take them. And unfortunately, you don't know that whether or not you're under investigation. And one of the messages, as a practitioner, we've been trying to tell our broker clients, as well as our importer clients, is if you are importing merchandise that is subject to a dumping order, you really have to take these requests very seriously. You really need to engage counsel sooner rather than later. The worst that happens is you're not under investigation. But as a practical matter, often if you get a very serious request, more than something out of the ordinary, please provide us document X, that should be a red flag.
Richard, you mentioned something in our preparations for this panel today that I thought was rather interesting. You indicated that when people receive, or when importers receive these Form 28s, they should operate under the presumption that they're under an investigation until they've received notice that they're not.
Absolutely. We represent clients that run the gamut of products. And some of these orders have been out there. I- There are orders that predate my beginning in this practice 30 years ago. I mean, these orders have very long lives, many of them. And so you have to assume that if you get a request for information on a product that's subject to a particular dumping order, that you should assume that you're under investigation. And, and I think that that prudence would dictate that.
Nathan, it looks like from the regulations that the record will be limited to submissions by the interested parties. If you're representing a third party out there in the trade community and has information that's relevant to this investigation, what would you counsel that party in terms of providing that information to the agency?
Well, the record can include anything that Customs wants. They have a lot of discretion to go out and get anything that they need to. And I think the concern within the trade community is if you do have that information, how do you best participate? And for practitioners and parties that are outside of it that are interested in these cases, interested in enforcement, what's key is the publication by CBP. And there is nothing in the statute or the regulations that obligates CBP to publish stuff. So now we're seeing these notices of action going out. When they go out, that is the way that the trade community is going to be informed that something is going forward. And then you have the time from the notice that the investigation has been initiated to go in and participate if you so choose. And then you can submit things to Customs, to the Trade Remedy Law Enforcement Directorate that you think would be relevant to their review. But what's essential then is that CBP give adequate notice out and timely notice out to the community to get that assistance. And in one of the cases that's happened so far, there was a pretty long delay in notice going out. The concerns that because it's not something that's obligated, Customs could decide that they weren't going to publish things. And in that case, there is no opportunity for other parties to opine on what the case is going forward.
Emily?
Yeah, so the parties that are parties to the investigation, which is a term that's defined under the regulations, are the party or parties that bring forth the allegation of evasion and the party or parties against whom the allegation is brought. There is a mechanism for CBP to allow other parties to participate in the process, both in terms of the collection of information, but also in terms of consolidating investigations. So it is possible for an entity that's not initially a party to an investigation to become one by submitting an allegation after they become aware of an earlier one. And CBP then has the authority to consolidate for purposes of administrative efficiency those investigations. And then that gives the entity that stepped in as a party after the original party filed the allegation the ability to fully participate within the context of the EPA process. That's something to be aware of. Consolidation is discretionary, but often in the best interest of the agency. But when it does happen, we are held to the original timelines that are triggered by the first filed allegation. And just quickly, I wanted to point out an important benchmark in this process. We have 15 days from the day that the allegation is filed to decide whether to investigate. But then we have an additional 90 days after the point that we make our decision where CBP, by the 90th day, has to make a decision as to whether to impose interim measures. CBP made the determination, because the statute did not, that the appropriate point in time to provide the alleged evader notice of the ongoing investigation was no later than 5 days after the imposition of interim measures. We can wait until the 90th day, which means by the 95th day of the investigation, we have to give notice to the alleged evader, or if we impose interim measures maybe 30 days in, then we would give notice 5 days later to the alleged evader. That 90-day window is an opportunity for CBP to conduct its investigation without providing notice of the official investigation to the alleged evader. Why is that important? Because sometimes it's easier to solicit and obtain additional information before a party knows it's under investigation. So that 90-day time frame, should we choose to maximize it, is available, but it certainly is not the case that we would maximize it in all instances. And interim measures are an important point in this process, because that's when CBP will extend or suspend the liquidation of import entries that could be subject, And it will also, at that point, require the collection of the additional duties that could be owed. So it's here financially that things get heated for the alleged evader, not at the end of the investigation, but at the imposition of those interim measures. Should we determine, and this is the standard, that there is reasonable suspicion that evasion is ongoing. So CBP has to use that reasonable suspicion standard no later than 90 days into the investigation to decide whether to collect additional duties that could be owed on the import entries that are for which liquidation is not final. So that's an important, I think, factor to be aware of in this process, because certainly from the perspective of the party making the allegation, this is the pressure that they want to put to enforce those AD/CVD orders.
With this framework in mind, Nate, would you like to give us a summary of what EPA proceedings have been filed over the past year, and maybe what are some of the concerns that have been expressed by the domestic manufacturers who are pursuing relief under the statute?
Sure. I just start off with stepping back as to why we are here. You know, the AD/CVD laws are pursued as remedies for unfair trade by domestic industries that believe that they need stuff to counteract unfair trade in order to survive. And you know, I've been practicing about 20 years. I think in the beginning of my practice, there is an assumption that once you get an anti-dumping duty order or a countervailing duty order, the trade remedy is in place. And what we have learned with more information as people have gone through and had experience with their cases is that assumption is not warranted. You know, the GAO has issued a report recently where they found that only 31% of the amount of duties assessed was on anti-dumping and countervailing duties was actually collected. You can look on an annual basis from what Customs is reporting to Congress that they are now making public, what are just some absurd factual circumstances where there are huge amounts of merchandise coming into the United States where the general tariff, the anti-dumping duty rate would be in the triple digits, and yet there's nothing being deposited on those imports that are going in. So EPA is a response to that. It is a way of trying to get more involved on enforcement and to try and see if the AD/CVD stuff can work. And that means that EPA is really focused on how you make the orders work. It is entirely complementary, and it is different than perhaps other ways that you might deal with evasion and circumvention, because what you're really looking at is what can I do to make it so that there is a market impact from these trade remedies in place. So 1 year of experience for CBP. There have been public notices out, about 15 investigations. Of the 15, 14 of them have resulted in interim measures. One was not initiated. They have covered 3 areas of evasion that's been confronted in the marketplace. The most of them have dealt with transshipment. That has led Customs to do overseas visits to factories and facilities where there were supposedly things being produced. And what they've found is consistent with what the domestic industries have been complaining about, is that quite often there are addresses used or pass-through entities used in other countries that do not actually manufacture anything. And the reports that CBP has issued so far of their site visits have been very helpful in kind of understanding how this operates. The second thing that they have been looking into in these EPA investigations is just straight misclassification, where a product is classified as something not subject to anti-dumping duties, when in fact it is concealing what the product actually is. The third has been, and this is sort of mixed right now, but there's one case where the agency is looking into, in the context of wooden bedroom furniture, the potential use of a foreign exporter that had a lower cash deposit rate than who actually manufactured it. So it usually is called deposit rate borrowing, or you're assuming the identity of somebody else. So that's the sort of the overview of cases. One of the things that's coming out of it is the different challenges that CBP faces in its evidentiary standards. The easiest seems to be misclassification, that what you're getting there is an ability for CBP to pop containers open and look at merchandise and to see whether or not that is actually classified correctly. When a container has been popped, that is something that they can look at and make a factual determination and say that we believe that this should have been a scope, that it was misclassified. On transshipment, on use of other anti-dump deposit rates, that is much more difficult for customs, and that will be something that I think will be presenting a challenge to the agency over time about how well they'll be able to sustain those determinations and how complicated it will be for them to conduct those investigations. Right now, on transshipment in particular, it's been easy because you go to a facility and there's literally nothing there. So that's been the sort of first part of it. I think it'll get more complicated as people continue to file these allegations.
Richard, let's discuss scope for a moment. The statute provides a mechanism by which customs can refer a matter to Commerce if there is a question as to whether the good falls within the scope of an order. And I think the sippy cup hypothetical is a great example of this. What do you see out there in the trade community, in the practical world, in terms of how often these scope issues are arising, and what would you counsel a client when they come to you and there is this question of scope?
All right, so let's talk reality here before we even get to EPA. Let's say we have the sippy cup, and we don't know if it is subject to the anti-dumping order or not. Customs will, at the agency level, the import specialist will say, go to Commerce and get a ruling. We can't make a decision. And most, without the authority of the agency, will also tell you, probably, we're going to assume it's in the case unless it's not, so we're going to collect the duties because nobody has ever fired us for saying no. But if we say yes, we can get into a lot of trouble. So the biggest problem is if you send this to the agency, to the Commerce Department for a scope ruling, a scope ruling should take, statutorily, somewhere around 60 to 90 days. In fact, we're running on average of 1 year. So, you know, if tomorrow there were an allegation about the sippy cups and the allegations were raised, yet there's no scope determination out there, I think Customs would be very, very hard-pressed to begin an EPA investigation without having a foundation to begin with. And the foundation is a scope ruling that says, yes, you're in, or no, you're not in. So I think that in real-life terms, we have a lot of challenges on a day-to-day basis on merchandise that may or may not be within the scope. But as to EPA, it's going to be I think it would be very hard, and Emily can comment, you know, further address this, but I think that they would probably, I would guess and I would hope that if the scope is up in the air, then I would hope that an EPA allegation would die of its own weight after 60 or 90 days.
Emily, would you like to speak to that?
So as I pointed out in the beginning, scope is a difficult issue for Customs because of our ministerial function. We're not involved in the AD/CVD initial determinations by the DOC and by the ITC. And so we have, under the EPA, the statutory right to make a referral to the Department of Commerce during our processes. Now, the statute itself does not specify when CBP can or cannot make the referrals. We believe that the referrals can be made any time up until the investigation reaches its deadline of either 300 or, in extraordinarily complicated cases, 360 days. Now, I just told you 300 or 360 days, but if we go to the Department of Commerce, that effectively stays the investigation, so that those timelines that are supposed to run under the statute are stopped until we have a response from the Department of Commerce. What's the effect? Well, I think you just heard how long it can take right now in public-facing determinations for Commerce to make its decisions. Now, whether Commerce has to follow the exact procedures it does in public-facing investigations, I don't know that we have the final word on that yet. But Commerce does have to make some sort of determination, which can be a time-consuming process. So it is entirely possible that before we reach the deadline for the imposition of, let's say, interim measures, we could reach out to the Department of Commerce for their input, which could then turn that 90-day period that somebody against whom an allegation has been brought would typically expect to hear within 5 days afterwards about whether they are in fact the subject of investigation into a much longer period of time. So it is something to be aware of. Certainly from the standpoint of a potential evader, wanting the input of the Department of Commerce could be potentially helpful, especially before the imposition of interim measures, where that's when you get that financial impact, if you will, that big issue for anybody against whom an allegation of evasion is brought. So I think understanding that there is a role here for the Department of Commerce, should Customs choose to reach out to them, is critical. And then just keep in mind that whether there's an EPA investigation going on or not, the agencies are able to communicate with each other when there are scope issues, and the levels of that communication can vary depending on the type of investigation that is ongoing.
I just add to that there's a practical implication to this. And when we're talking about allegations or what launches EPA, I left out the fact that the government agencies can also make referrals. But if we just stick on private parties making an EPA allegation, if it's coming from a domestic industry, it's because it's a concern regarding those imports, which means that the industry believes that it is within scope, that they intended the trade remedy to cover that merchandise that's coming in. If you've gotten to a point where it's not clear that whether it's in or outside of scope, EPA is probably a really bad place to try and litigate that through, because it will get lost in the referral to commerce. And so that should be a natural check on how much of a problem this will be. As a practical matter, if you're looking at these sippy cups and you are concerned with your ability to sell into a marketplace where this merchandise is coming in, and you filed an EPA allegation, you're likely doing that because you have seen in the trade data, in stuff that you're going, or with customers, that you can confirm with bill of lading data from private subscription services, that there's actually imports that are coming in. And what you mirror that with, or what you check that against, is the admin review process. And so when we talk about the story behind the story, one of the reasons why domestic industries make admin review requests that cover hundreds of exporters as a routine matter in cases is because it is the only way you can ever get to look at Type 3 data from CBP. What is being announced or declared at importation as subject to AD/CVD. Under the administrative protective orders that Commerce issues, you put in your request. Commerce makes a request to Customs as to the Type 3 entries that are related to those exporters. And what you can learn from that, or what I constantly learn, is that most of the stuff that we're concerned about is not being entered as Type 3. And we will take that and go back to Customs, whether in EPA or in a different format, and say, we need you to look at this merchandise because we think that this stuff should have been subject in scope. And the indications are that it's not. And we will also then make withdrawals on the admin review requests of stuff that didn't get declared as Type 3, usually at the request of Commerce, just to make it cleaner and easier for those admin reviews to be rescinded. So all of this stuff kind of plays together in different ways, and we again want to make it so that we're really just focused on the merchandise that you think is coming in that's having a harmful impact in the marketplace on your domestic industry clients. Sure. Well, do you want to do it?
Happy to do it. Customs has different entry types that are made when goods are brought into the country. The most common entry type is the Type 01, which is an entry for consumption. However, if your goods have AD/CVD duties associated with them, you have to make a Type 03 entry. That tells Customs that you're identifying an AD/CVD order or orders on your import entry and depositing the money at the rate that is believed to be applicable, although not final, at the time that the goods are entered. So those Type 03 entries are telling Customs up front that you've paid your duties, and from an evasion standpoint, maybe you've identified the wrong case. That's a potential concern. But the Type 01 entries are where you're going to have your misclassification errors in a AD/CVD evasion type context. So those would provide the HTS code, just like all entries do, but they wouldn't usually identify an HTS code associated with an AD/CVD order in an attempt to sometimes evade having to make those deposits, which again are very hefty deposits that have to be made under those orders.
Our duty assessment system for anti-dumping and countervailing duties overall is tied completely to the Type 3 entries. The statutory injunction is injunctions on Type 3 entries. The Commerce Department's admin reviews are reviews of Type 3 entries. And so the easiest way to opt out of all of this is just to declare something as not Type 3, and then it presents all the challenges that EPA is trying to get to in enforcement.
Of course, if interim measures are imposed, we collect those deposits, and your entries, if made as type 01s, would be converted to type 03s at that time.
I think one last thing that we should add to this, for those who don't do this on a daily basis, is that when entries are brought in, duties that are paid are estimates. In the case of type 01 entries, goods that are going to be consumed, there is a procedural mechanism to liquidate them or make them final within 315 days. For 03 entries, they are open-ended and can live for many lifetimes. So it is possible, we've seen many cases where anti-dumping duties, a deposit may have been done at 12%, and 7, 10, 12 years down the road, anti-dumping duties could be finalized at 250%. So the transactions are not complete, they're open, and they go on for years, and in fact can put people out of business many years later without even their knowledge that this is going on.
Yeah, and this has a very practical, again, impact on the way that you think about enforcement of AD/CVD orders. If customs is tied to when you actually collect on assessments, that can take a long time, well after the imports have come in. What EPA allows through interim measures is to be able to have a market impact rather quickly, that you're talking about whether or not you're paying the cash deposits, not necessarily assessments. In their discussion, Judge Gordon and Professor Colares talked a little bit about Rupari. There is a 2015 case that was before the Federal Circuit, sort of went through the facts of Rupari. Rupari is about crawfish tail meat transshipment through Thailand that occurred in 1998. And that's the calendar that you're looking at when you're talking about enforcement sort of through the traditional stuff, well after whether there's going to be a market impact or not. EPA gets you to those points of having, requiring cash deposits on entries sort of very, very quickly after the behavior is identified and the investigation is initiated.
So with these complexities in mind, Richard, why don't you discuss with us a little bit about what alternatives are there to the EPA? What other statutory mechanisms exist if a domestic manufacturer wishes to further pursue enforcement matters?
All right. So I'm going to talk to this as a practitioner, as a day-to-day practitioner who represents importers, who represents customs brokers. And I think that the way to talk this through is start by how do one of these cases get started? We heard already that the government may initiate their own case. But there are other ways that these cases get started. Competitors can bring an EPA allegation. And finally, my personal favorite one is what we call in our office the former employee rats you out case. So we see those not just in the anti-dumping context, actually, we see them in many different cases. But I think that in that context, TIFTIA, when it was implemented, the interim regulations went into effect in August of 16. The very last regulation on the list. I'm sorry? Are you talking about the Trade Facilitation Trade Act? Yes. Which then led to EPA. The last regulation, 19 CFR 165.47, essentially says that nothing in EPA precludes any other remedy at law, equity, or anything else anybody can cobble together. So the real question is, what are the other remedies? So there are essentially two different things to look at. Now, Judge Gordon earlier today mentioned 19 U.S.C. 1592. 19 U.S.C. 1592 is, for lack of a better description, it's your general purpose negligence, gross negligence, fraud, for whether omission or commission. It's penalties for pretty much anything under the customs law. And in addition, there is the False Claims Act, which I'll get to in a minute. So in 1592, you have a material misstatement which is made, and the potential penalties to the importer run from negligence from up to 2 times the loss of revenue all the way to fraud to up to 8 times the loss of revenue. So quite a possible point. Now, at this point, the question is, why would we use that as a mechanism? Now, I will tell you, up until the creation of EPA, the way that we often got relief in these cases, where we represented one importer who was following the rules and we were trying to stop somebody, is we would go to a friendly auditor, investigator, branch chief at Customs and say, we've got this person, they're doing all these things, and here, by the way, are 6 loose leaves of documents telling you exactly what they've done. Now, under 1592, if you rat someone out, there is actually the potential for a financial reward. That financial reward is called a moiety. Now, a moiety is a misnomer. I will tell you that in this room, although in its earlier incarnation when I studied Admiralty in this very room 30 years ago, I was told that a moiety is 50% of whatever you recover. Well, the statute doesn't allow, a moiety is not 50% under the customs statute. It actually, 19 U.S.C. 1619, it says that the recovery should not exceed 25% up to $250,000. So that was one reason to go. A, you could collect some, you might be able to make some money, but 2, you could get Customs to help you stop bad behavior. The problem with 1592 was there was no transparency to the person who outlaid the claim. If we went to an agent, I mean, maybe they might tell us they've taken some action, but generally, until we saw it happening in the marketplace, we really didn't know what happened. There was no transparency. And often in cases with 1592, when we were looking for a moiety, when the client was looking for a moiety, there was also there was always a struggle about whether or not they deserved to be rewarded for ratting someone out, and did they tell somebody information that was already in Customs' hands, and so forth. But in the last 20 years, since the mid-'80s, probably the most popular method was under the False Claims Act. So just by way of history, the False Claims Act was created during the Civil War so that subcontractors wouldn't sell bad bullets to the North so that they could make sure that they actually really killed the soldiers from the South. That was why the False Claims Act was created. Today, so in 1986, the government, Congress enacted some revisions to the False Claims Act, which allowed for what are called reverse false claims. Reverse false claims are where you tell something to the government and it causes the government to lose money. It's not that the government has gone out and spent bad money, but the government is losing money. And the government has, under this, can get monetary penalties, and probably the biggest monetary penalty besides the loss of revenue that they collected was that for each claim, so some people say it's per each entry, some people say it's each line of each entry, $11,000 per claim the government could collect, plus attorney's fees, plus costs. Now, the False Claims Act used in all the cases that were described before, whether it was classification, whether it was by saying it was from shipper A rather than shipper B. But the False Claims Act, the long and short of it is that any private party could act as in the shoes of the government and file this case. It had to be done under seal, and the Department of Justice had the right to, within 60 days, determine if they were going to take these cases on or not take these cases on. Let me say, as an aside, that early on, the Department of Justice was very anxious to take these cases on because they were great moneymakers for the Department of Justice. In the past several years, you could go to the Department of Justice with, evidence, absolute slam-bang case, and the assistant U.S. attorney says, look, I don't have time for this, you go do it yourself. Now, remember, we talked about a moiety in the 1592 case. Well, under the False Claims Act, if the government decides to act for you, which is the best of all possible worlds, because then you start the case, and then you have the force of the U.S. government taking over the case, you still get 15 to 25% of the money. If the government decides not to take the case, you actually can get up to 25%, and there's no cap on it. So in a case, not an anti-dumping case, but in a recent case that had to do, it was about the valuation of merchandise by a little company that probably a quarter of you in this room will know because you have their product, a company called Otterbox. Otterbox had an employee went to management and said, we think you're undervaluing the merchandise because the merchandise, you're not including all of the value. And what happened was management said, go away, you're going to cost us money. And she went to management several times, and finally management had enough of her and quit. Remember I told you there was the former employee rat? She was the former employee rat. What happened was the case proceeded. There was a penalty case that went on simultaneously. And the Otterbox case was settled. Now that was the good news and the bad news. It was good news for the person who brought the case because she got a reward of $8.2 million for ratting out Otterbox. The bad news was that there were certain issues that never really got decided. And Otterbox was a case of first impression in one principle, and that principle was under what is known as the public disclosure bar. If Customs already knew about a problem, you can't collect on it in a False Claims Act case. And because Otterbox was settled with no guilt, despite the fact that she collected $8 million, we don't really know what the law is. The law is still kind of open about whether or not that bar really exists. The other thing that I will mention is the jurisdiction of the courts. Today we talked a lot about the Court of International Trade. What I will not talk about is the tortured history of all the cases that went through the CIT. And in the end, jurisdiction is in the local district courts. I'm just going to leave it at that because it was kind of a painful process for both the judges and the bar, because the bar and the judges, I don't want to speak for the judges of the court, but I would say that the bar really wanted these cases in the Court of International Trade. They felt that the Court of International Trade understood the imports and really understood it. Unfortunately, after going back and forth between the district court and the CIT, jurisdiction is in the Court of International Trade. I'm sorry, in the district court, not in the Court of International Trade. So the last issue that kind of comes up in all these cases, I alluded to in the Otterbox case, is what happens if the importer does make a prior disclosure sometime right before the person goes and makes any kind of allegation, whether we're talking about EPA, whether we're talking about the False Claims Act. Prior disclosure is part of the same statutory framework of 1592, which essentially says, in short, mea culpa, I have sinned, here's how much I've sinned, here's where I've sinned, here's the money, and it stops the clock from running on any potential penalty. Remember, I told you the penalties were under 1592, 2 to 8 times the loss of revenue. The penalties then get locked in at interest on the money you owed, for negligence and gross negligence, and for fraud, which frankly, I don't know that I've ever seen a fraud prior disclosure ever that's worked its way through, but if it were, at least in theory, it would be 2 times the loss of revenue plus interest. The question is, and this again is an open question, is a prior disclosure still available? That question has not been touched yet. I am guessing over the course of the next year or two, somewhere along the line in an EPA investigation, someone is going to raise the flag. I've already disclosed this. Why are you making this case? And that's going to work its way. The prior disclosure piece will work its way through the Court of International Trade.
So with that, let's take some questions from the audience. We have about 5 minutes left here, and let's see if anybody has. Bo.
Just one quick comment, Richard. I'm proud to know that Otterbox did get that back in more by winning a customs classification case at the CIT. Proper classification of phone cases. So they took a hit there, but prevailed on a bigger customs issue.
Oh, absolutely.
Any other questions? Yes, over here.
Yeah, quick question. First is, when Customs does refer a scope determination to Commerce in the course of an EPA case, when might the party that the scope, the importer, be able to appeal that? Would that appeal go on simultaneously with the EPA case, or would that be separate? And then for Justin, with the absence of an administrative protective order, how does defending these cases, how is that going to be different for you at the court?
I'll have Emily go first, and then we'll talk about that.
Okay, so if the Department of Commerce makes a determination with respect to an EPA proceeding, at that point CBP would act on the determination from Commerce. So let's say they did say that the sippy cups were within scope. We resume our investigation. The 300 or 360-day timeline applies. We make our decision. It seems entirely possible that the decision by the Department of Commerce could be challenged within that time period. Whether or not that challenge would stay the EPA investigation, I think, is an open question. It is possible that if there is no final resolution on that Department of Commerce determination, if they've told Customs that it is within scope, we would proceed with our investigation. And it could, in fact, be the foundation for a final determination that the goods are, in fact, subject, and that CBP will proceed with its EPA investigation finding, which would be affirmative as to the violation. And at that point, there would be a window for an administrative appeal. So potentially you could raise those issues in the administrative appeal. Otherwise, whether the appeal is done and there's a certain amount of time after that or not, at some point that EPA determination will become final, and in order to disturb it, I think you would have to move into the courts to rectify things if down the line that Department of Commerce determination was in fact found to be incorrect. But again, these are open questions with regard to how EPA investigations will be handled.
To follow that one up, then, how would you, if you're not, then you're not actually challenging the actual final determination of the EPA investigation, you're actually challenging the scope, so how would you prevent liquidation of those entries in the meantime?
Well, I think that there are opportunities available to seek injunctions and other sorts of restraint with regard to the liquidation of entries if in case it's contemplated that there's an issue down the line. It hasn't played out yet, but I would imagine that you would want to stop Customs from making those liquidations final, notwithstanding the determination in the EPA investigation.
In terms of protection of business proprietary information, the court, through the court's Rules Advisory Committee, is currently discussing a format for transmitting BPI from the agency to the court. Some of the items that they've discussed is something similar to what we would see in an AD or CVD proceeding. If that framework is ultimately adopted, I think we're going to see something similar to what we do see in our trade cases. We have not had an EPA case yet have been appealed to the court. So it's yet to be tested. I mean, we could always protect the information through a judicial protective order that the parties will negotiate at the outset of the case, but they're hoping to streamline the process somewhat akin to the trade format. Any other questions? Yes, right.
Like Richard, I represent importers. Hearing the definition of evasion, it seems difficult to draw the line between negligence under 1592 and evasion that would launch a CBP investigation. Many of these importers of sippy cups and lots of other stuff tend to be small companies that might make a misclassification, that they may make an honest error or their broker makes that error. And I'm concerned about the delay in notification, that 90-day period that we were talking about. Wouldn't it be a better policy to give notice as soon as there was sufficient information to determine that this is a misclassification error as opposed to an actual evasion where the goods are misdescribed or something like that?
So a couple of points on that, and I think that that does happen. There are importers, mom and pop shops that make mistakes in certain situations and maybe don't have the level of culpability that a sophisticated importer would. But with respect to first the definition of evasion, there is no element about mens rea. We don't require negligence, gross negligence, fraud. We don't even require intent to invade. It simply is that you either did not pay the AD/CVD that was owed or you paid the wrong rate. It's really a factual determination under an EPA investigation. And why is that? Because the EPA investigation is not a punitive process. It's there to enable the government to recover all of the revenue that should have been paid on those entries. However, this is a case-by-case sort of scenario, and while we have up to 90 days to make our decision on whether to impose interim measures and an additional 5 days after interim measures to provide notice of the investigation that is ongoing, CBP would have within its discretion the ability to notify maybe a small actor that they didn't believe was trying to engage in anything that was inappropriate, maybe at 5 or 10 days out. They would probably impose interim measures if the goods were obviously within scope, but CBP is not necessarily going to sit, if you will, if there's no reason to sit on those allegations. Now, if they suspect that there are other parties that could be guilty of evasion that are cooperating with the alleged evader, might we be silent for the additional 90 days in order to identify those other parties and proceed against them in some other sort of way? Absolutely, but we're talking about perhaps a sole mom and pop operation. I don't know that the incentive is there to wait the entire 90 days. CBP doesn't have an interest in letting, misconduct continue to accrue, if you will.
But I just would say, to add to that, the CBP is not going to investigate evasion just through EPA. And as a practitioner, when you're concerned about evasion, you're going through the different options that you have to go forward. And certainly, I spent a lot of time when TFTO was being considered telling everyone that EPA wasn't going to be effective and wasn't going to do anything. That turns out not to be the case. But still, in each one of the places that we're deciding whether or not to bring an allegation, we're making a decision whether or not we go on the criminal side, where we want investigations that's sort of out of EPA, and then work with those parts of the CBP outside of TRLED that would work on those aspects. There, you're not going to get any notice. The investigation will come. It will all be built up before you get told. So there is, the way that EPA works is it has protective measures both for the domestic industries that are filing these allegations and these procedural matters that are in place that importers can look at, and they can use those as protections. But the more that you move it towards pro-importer, the more we're going to move to the other aspects of CBP, where they will have a lot more discretion to take enforcement actions.
With that, I think we'll conclude for the morning. I think you have a 10-minute break, and we'll resume here in 10 minutes. Thanks, everyone.